Allowed in terms of DGFO, DGOF.
Highly obliged.
Within 12 weeks, they will have to.
Highly obliged.
Question of territorial jurisdiction. Petitioner's contention is allowed. However, alternative remedy dismissed. Pathagur, what is your expectation? This petition stands dismissed. Right.
May it please your lordship, I'd like to mention item number 12.
Item number
12. Lordship, we are the newly implemented respondents, and I am appearing for respondent number 8.
you have for respondent number
Yes, Your Lordship. 8.
item 12
Yes, Your Lordship.
on the prayer of the Learned Council for the respondent number 8. Matter stands adjourned and be listed after 3 weeks.
Lordship, I may appear for petitioner.
Legal aid.
F. Begum on behalf of S.
A Begum on behalf of S. Boni for the petitioner.
Obliged.
Item number 16 and 17, Lordship, kindly adjourn the matter.
16 and 17.
Bail matters.
Bail.
But
Yes, case there is there, miss.
My lord.
When?
next week, Lordship.
Yes, on the prayer of the Learned Council for the petitioner. Matter stands adjourned and be listed on Wednesday next. Listed on 28. Case diary be written.
Lordship.
My please, lordship. My lord, item number 18, my lord. Case diary not received, my lord.
18 has been mentioned, 17 and what is?
So the 16, 17 mentioned, my lord.
Okay, 16 and 17. Okay, 18 case diary not
Case
received.
diary not received.
When?
My lord,
Wednesday?
my lord, after 13, my lord, I will, not
After
available.
13, give a date.
on 16, my lord.
16th of September.
Obliged. 16. Can copy pirates not received.
Can copy was received on the last date, your lordship.
Received.
Yes, your lordship was available on the last date and learned PP sir has
Okay,
time
it's sometimes.
Causally smell at that.
So go through it
My lord,
on Tuesday.
Your lordship, the accused is behind the bars already for more than 176 days.
We understand. That is the
but,
case.
then I'll go through, my lord. Otherwise, my lord,
Okay, go
after
through.
some time, my lord. I
Go through
to
because
the
today is
call
you go
list
through
because
it. We'll take after some time. After the list is over, you have some other work.
my lord, this could not-
You complete it, come back thereafter. Go through it.
Pleasure.
My lord, in fact, one instruction, my lord, but not in regard to that, with regard to your lordship's order.
Mm.
Lord, I am told that the, my lord, government in the corporation department has recently requested the learned advocate general, my lord, to represent the government in the present case.
Mm.
But since I could not get in touch with him, so lordship will kindly give me 7 days or 10 days time. I'll take up the matter with the learned advocate general, my lord.
Otherwise also we can pass order. We want to,
Some
Something.
resolution to this.
if advocate general is there, he will have some authority to say something, which is other council will not have.
Yes, that is why, my lord.
It is
2 weeks
submitted
time we will
that
give.
taking the importance of this matter, the state has decided to, state has requested the learned advocate general to appear in this batch of writ petitions, inasmuch as this batch of writ petition may also involve the revival and oblique or liquidation of Escart Bank. Full stop. Accordingly, a prayer for adjournment is made. Full stop. Prayer is allowed. List this matter.
In the month of, my lord, first week of September, my lord.
5th of September.
5th of September. 5th of September. In the meantime, Mr. Talukdar, the learned counsel, you will assist AG, I think.
I have been informed to assist him, my lord.
Okay, who is assisting the advocate general, may complete his
My lord,
instruction.
your lordship may say I'll take up the matter with the learned advocate
Okay.
general. my lord.
No, we'll say the Mr. Tal not assisting. Mr. Talukdar, learned standing counsel for cooperation department, in the meantime, may complete his instruction in terms of this court's earlier order dated 23/7/2024.
Obliged.
List accordingly.
Obliged, deeply obliged.
His lordship.
Yes.
The maternal death case, lordship, and in fact, government was supposed to take instruction.
What is the other matter and when it is fixed?
It is fixed on 27th, lordship.
27th.
Yes, lordship.
We'll take up this matter along with that. Yes, government.
Health Department. That is fixed on 27th, the other one. And
Any
inquest
committee constituted?
that they have to give the updates, lordship. We were not being informed as yet.
This is the commission.
Antina.
Health. Where is health?
Health Department.
Wait for some time. Is inform the health, standing council health.
Lordship, one more last case.
Complied with.
Yes. I've got to.
Forget about it. Their statement is that they have not been able to contact. Mr. S. Borua, learned counsel for the respondent. In terms of this in terms of this court order dated 19/8/2024 has submitted his written instruction, which suggests that the petitioner, namely Dharmajit Dole, has been paid an amount of rupees 7,50,000.
No, that was the amount, but in total, he was paid 9 lakhs.
An amount of rupees 9 lakh has been paid.
And that has been paid in terms of that mutual agreement which has been entered with the authority.
9 lakhs. No, we'll say it's already
Amount has been paid. all the company.
amount will not say amount.
That's
It says that the amount claim has already been paid. Full stop. None appears for the petitioner on call. In view of this, in the aforesaid stand of the respondent, matter stands. Yes, closed. No, none appears. Land counsel for the petition. Closed.
25.
Yes.
Lordship, service regarding response number, private response number, Lordship.
Yes, Mr. Samawati.
Yes, Lordship, they have not served copy upon us also. We are unable to get the instructions.
What is the issue here?
Lordship, there is a illegal construction of a building, Lordship, over a plot of land of the petition, Lordship.
Where is the Lawajima?
Lordship, the reports, Lordship. Page 20 is the.
What about respondent number 6?
Lordship, she constructed the building over.
No. What about service? Who construct? Are you for respondent number 6?
No, my 2 and I have to take fresh step. This is for her address, Lordship.
Okay. In terms of
Executive officer to me, Lordship.
in terms of Lajima Courts Order dated 19/8/2024. Learned counsel for the petitioner submits that he may be granted 10 days time to take fresh steps upon respondent number 6 in proper address. Full stop. Prayer is allowed. List of the steps be taken within a period of 10 days from today. List this matter after 4 weeks. In the meantime, the learned counsel for the petitioner shall furnish extra copies upon the state respondents so that the state respondents can complete their research.
Everyone.
Mr. Wait, we'll just finish up the other matters. Can you wait for some time? Two, it may not go above to two. We'll wait for just some.
I will come.
Well, since we'll have to hear this matter, is not it?
Standing second number 23.
Yes, health.
Lordship, we have received our instructions and the committee's report has been given to us. Lordship, may give us some time, we'll put it by way
Okay.
of note.
The learned standing council for the Health and Family Welfare Department submits that they have received the inquiry report in terms of this court's order dated 27/2/2024 and would like to bring the same on record by way of an affidavit. Full stop. Accordingly, the matter stands adjourned and be listed on.
Lordship, 2 weeks, Lordship.
Give a date.
Uh, Lordship, can it be listed on the 5th of September?
5th of September. Full stop.
Seven.
In this case, I was requested yesterday to appear. We have filed an affidavit.
It's good that you are not, no affidavit is required. Mr. Advocate General, there is a subject to what you said. There is a mess. So for regarding.
So that has been already rectified by the 2017, because now there is no scope for any selection.
No scope, no scope.
Everybody is getting
No, that's true. But what we are facing is that
prior to 2017.
prior to 2017, so many cases and it is repeated year after year after year. And some
Actually,
if
those cases do not
some
deserve any.
clarifications are there in your procedure, how to deal with that, further clarification, because basic grievance is that my file was long back, it was not considered, it was kept pending. All these things are there. If some clarifications is there, I think these litigations can be. This
Now,
is
Lordship,
wastage of
one
state
thing is
money,
very clear.
everything. That we
Till-
don't have anything beyond that streamlining this, nothing more.
Now, my submission would be, Lordship.
Hmm.
So from 2017 onwards, those who died in harness,
Gone. That's a,
that problem is no more there. So
Hmm.
everybody is getting the salary till superannuation and thereafter
that's
the
the good
pension.
policy. There is
Very, to overcome all these
yes, there
issues.
is no very welcome.
Yes, that
stand.
was during the last government, we have very
Ah.
consciously we have taken the decision that there is always some lacuna somewhere. Lordship has rightly said, clause 9, clause 15, those lacunas were there.
Yeah.
But now the law is very settled that if a person died in 2017 and prior thereto, they do not have any right for, so that settles the whole issue.
No, that settles the whole issue. The difficulty is not here there. Suppose there is an action on the part of the government in processing the file indiscriminately. Because
now-
there are many judgments in our courts.
I understand, Lordship.
This is creates the difficulty. See, as a otherwise simple, in view of the recent judgment of the Supreme
2
Court.
years time.
2 years, and that can go. So in terms of that, if you can have a policy in that respect also,
Now we cannot go back. We cannot put the clock back.
you cannot.
No, we cannot. So
Now,
now,
so
whatever
it's-
may be the policy decision today,
Now, so therefore, safety is on the court. And therefore, too many, sorry to say, too many diverging opinions in many cases.
yes, Lordship. Yeah,
Let's be fair. That's
Yes,
why
Lord.
we are happy that you are here. That is the idea how to resolve this issue if
No,
possible.
we are conscious of the problem and we are trying, that's why the Chief Secretary requested me to appear, and whatever this honorable court directs, we are going to implement. But the thing is that already to overcome all these situations.
Mm.
That 17 policy was brought into place. So there is no question of any selection, no hardships the family is facing. All these criteria are no more relevant.
No, that
Now,
gone.
one thing is, so far as this case is concerned, he died in 2015
Mm.
and he came before this honorable court in 2021.
Mm.
By that itself shows that he was delayed.
Mm.
If the
No, this is a case as a sample, sample. Because at that point of time, while taking the bench tree, different issues, different judgments, in some judgments specifically said, and those are byproduct of those judgments. Now, how to deal with that?
So now, what this government will do, lordships, because government are also getting conflicting direction.
Help us. That's why you are here. Advocate General is here
So,
for
Lordship,
that reason only.
one way of looking into that, those cases do not have
Affidavit
any
file?
life.
Affidavit file?
We have filed, lordship.
When is your next free date? Tell us.
For first week of September, lordship.
First week of, I will go through the affidavit. I
Lordship.
somehow could not go to it.
Yes,
I'll go through the affidavit.
lordship.
Your individual case will decide. See,
sir.
law is now it's very
The
clear.
Lordship has very correctly said in the last order,
Mm.
there is conflict.
Mm.
But whether we can, and number one,
And
the
conflict
policy is not
also-
on challenge.
Conflict also we can understand
Yes.
when that it's a new fresh kind of thing.
Yes.
But these are byproducts of litigations of 3-4 rounds,
Absolutely.
sending it, taking that, no, we have committed wrong, you have not given to him, reconsider it.
Right.
Again, they reconsider. Now the third party, right? Many things are there.
Yes. Now, suppose lordship is not happy with clause 9 and clause 15. If those are removed,
Mm.
then also it will go against them.
Against them.
It will go against
Against
them.
them. Our idea was to, as a whole, look into whether there can be some tweak and twist here and there to resolve this issue.
Yes, lordship may, whatever,
that one
we are
where-
open to it.
Mm.
We are not considering this as an adversary.
No, this is
litigation.
not an advisory litigation. We'll take note of you are waiting for so many years, you'll wait for some more time.
It is sometime around 6th of September.
6th of September, an affidavit has been filed. Learned Advocate General has also entered appearance on the request of the state, taking note of the importance of the issue raised. Full stop. Accordingly, the matter stands adjourned and be listed on
6th of September.
6th of September for further deliveries.
Highly.
Mr. Advocate General, I think there are another matter so far relating to Escort Bank. Some
Yes, that also the government is trying.
see in that case also judgments after judgments from Supreme Court.
My request, I get the oral request. Lordship will kindly give us 2 weeks time. In the meantime, we'll take a final decision. Because
See,
the assembly was going on, therefore the
we understand.
departmental
We have
council.
given a date something somewhere when
Fifth.
5th, same date,
5th of September.
5th of September. Because here also
Let's see on 6th of September.
so many contempts, so many
Yes,
judgments,
Lord.
but how to implement
Government
it?
will have to do certain things.
Certain,
Yes.
either you liquidate it,
Yes,
give
Lord.
them benefit, or you revive it.
It
if
was sent
possible.
to the CM's office, but it could not be done because the CM was outstation and from today the
That
assembly
is
has
also an
started.
awkward case where they are saying this is the Supreme Court judgment, but
Yes, yes.
from whom will you get money?
Yes. Whether it is a state government's agency or not, that is one
That is also,
question.
and
That
we-
call the government will have to take, whether it is a state instrumentality
Mm,
or not.
yes,
Under Article
those
12,
those issues are there.
Lordship.
Now, against whom the order will be implemented? These are
This
issues.
is on 6th, because
Sixth.
the other side is also a 6th. Both the
Sixth.
cases I will appear on that day.
6th, okay.
6th.
No, that series 6th, okay.
Highly authorized.
Yes, where is
Government was.
nothing, government was to bring the record, Mr. Sharma.
Received the records.
First tell us whether award is there, any approval, any award, nothing.
That is why, this is the one, I have just gone through the forwarding.
No, I
letter.
think that once was available on last occasion also.
This is, yes. No,
See the predicament, the deputy commissioner has decided everything. Who will
But the
get, who will
award,
not,
yes,
award is not
not
there.
there.
So if there would have been an award, he can go or she can go, anybody can go to the referral court or
Yes.
he can send it to the referral court. See, now the person in whose favor money has been sanctioned is without an award. That cannot be. And if that be so, suppose there is an award for the pendency of this case, there is a stay, she is not enjoying. At the same time, he is also having an anxiety.
Lordship.
So what to be done today?
As because, yes, Lordship, this instruction I have just now
Is
gone
that
through, it says
instruction of which date?
20th of March.
On 24/7/2024, we have passed an order. Press further 10 days time to obtain record of LKS PFO in original in terms of course earlier order dated 21/3/2024.
This is not the, this is the photocopy. So Lordship, regarding that, Lordship, we have not yet received the.
Now, whether you have
original.
communicated
Yeah, the letter was communicated.
after 24/7,
On 24/7, Lordship, one letter before.
or let the deputy commissioner say there is no order, we have passed an affidavit.
Lordship may
Uh,
Lordship may fix it on.
Mr. H. Sharma, learned government advocate, submits that the original record of LKS number 05/2021 in original has not yet been received. Full stop. It is seen from the order dated 21/3/2024 that though records were produced, the award on the basis of which a payment was decided, compensation was directed to be made in favor of respondent number. You are respondent number, he is respondent number? Respondent number?
Where else?
A private respondents.
Private hospital.
Private respondents. Full stop. In the aforesaid context, if the records are not available, if the award is not available, the deputy commissioner shall file an affidavit incorporating the following. If whether any award was passed, full stop, in a award was passed in connection with LA case number 05 of 2011. And if not, under what authority and under what provision of law the deputy commissioner has passed the impugned order dated
Order dated, Lordship,
impugned
3/10/2017.
3/10/2017. Full stop. List this matter on.
Last part of September, Lordship.
Give a date.
Lord.
27th of September. Full stop. Affidavit be positively filed
Lord.
before the aforesaid date.
Mama.
Before the aforesaid date. Yes. Ready?
Yes. So the petitioner.
What is the issue? In some summary, Cooperative Societies Act.
The petitioners,
Cooperative Societies Act.
the
Any
peti-
private respondent here?
But Lordship, I have made some certain allegations against the respondent number 7.
Hmm.
With regard to demand of illegal gratification,
Hmm.
but she has not come before this honorable court and filed affidavit. That was our. And Lordship, the affidavit has been filed by the superintendent. Much below rank officer, Lordship. Because although there are respondents.
Lordship, I am appearing on behalf of respondent number 7, Lordship.
It is filed question. Huh?
Affidavit was filed by respondent number 3.
Okay, you have not filed. You don't wish to file.
Lordship, I think we have filed. it,
No,
Lordship.
don't I think. Tell, be clear.
It was back in 2019, Lordship.
You want to file, he's enjoying a stay order, let him enjoy the stay order. And if you do not wish, we'll,
Lordship, the issue here is that, Lordship.
no, please answer this question.
Yes,
Would you like to file affidavit?
Lordship.
Tell us that, then you incorporate your issue in the writ petition. The learned counsel for the
Respondent number 7.
respondent number 7 prays for and is granted 3 weeks time to file affidavit in opposition. Full stop. List accordingly. Interim order passed earlier shall continue until further orders.
Alright.
Yes, you have gone through the city case diary?
Yes, my lord, Dean Arthur, my lord, appear, my lord, he is in the election, my lord. No, after some time, my lord.
এই কিতাপখন দিয়াচোন মেণ্টেল হেল্থ এক্ট Yes, Mr. Gogoi.
Require some further time is under process, but because from today the assembly is.
Okay, so basically you also agree that you are
One thing I would like to point out, the main prayer made in the petition is regarding yes. Rule is the larger issue. They want that my lord as per this definition of magistrate. Proceed mechanically the act. That was the core issue, my lord, which came up on the very first day.
Yes, Mr. Pushya, you are appearing for whom?
Short man. Kindly pay with section 124. It has to be.
No, we'll come to all those issues later on because primary issue raised is the notification of magistrate
Yes.
because some offenses are there, many procedures are there which is to be dealt by the notified magistrate.
Yes.
Magistrate.
That is.
So until and unless magistrate is there, certain aspect of the act cannot be implemented.
My lord.
So issue is very important.
Perfect.
So forget about the prayer, what the prayer is meant. So if you are in the process, this is not an adversarial litigation.
Yes, yes.
So we'll
course.
adjourn it and we'll,
Let it be after 4 weeks in that case, because
Okay.
by
okay.
this end of this month.
A small submission.
Yes.
I have found the answer to your question that why CDM code.
Mm.
Part of that answer has been filed in additional affidavit and which is in process. And I believe it will be tagged in a day.
Where is that? You have given something. You want some time?
Yes, sir.
Okay, Mr. B. Gogoi, learned standing counsel for
Health department.
Health and Family Welfare Department submits that he has instruction to seek 4 weeks time to complete his instruction in as much as at this stage it is his instruction that the Health and Family Welfare Department has taken active steps for framing the Assam within inverted comma the Assam state mental health rules in terms of section 121 of the Mental Health Care Act 2017. Full stop. However, due to ensuing sessions of Assam Legislative Assembly, the draft rule could not be finalized by the Health and Family Welfare Department. In view of the aforesaid and considering the larger importance of this writ petition, prayer for adjournment stands allowed. List this matter after 4 weeks. Give a date. Give after 6 weeks. We'll give it give after 6 weeks. Okay, give after 4 weeks, then if necessary,
Yes,
because there will be some consultation process will be required.
25th month.
Another date, please. That I
30?
30.
30 of
September.
Of September.
Yes.
Public. Much. Please.
Affidavit is filed.
Lordship,
Yeah, file or reply also.
Reply
Reply is here in the on record.
Yes, Lordship. Yes, in the report.
Thank you.
Yes, Mr. Das, you are for whom?
I am for private respondent number 1, my lord. That is,
Now tell us the clause where they prescribe for contract, that contract labor certificate. Only issue is the certification, nothing more. License, labor license. Where is the clause?
page 55, your lordship.
Page
55 of my writ petition. It starts at page 54, but the operative portion is at page 55.
page
54, if your lordship comes to page 54, qualification criteria,
page 54. Just a minute.
down below, your lordship.
Page 54, clause
Clause 2A, D,
Clause 2A,
small d,
small d,
small Roman 3.
small Roman 3. Page
Page, it's,
54 and 55. Okay,
yes, your lordship.
let us read it.
It says,
Yellow marker. Okay, fine.
yes, qualification criteria, breeders should demonstrate that they fulfill the following qualification criteria. Now, next page, your lordship, small Roman 3, EPF with up-to-date payment challan along with up-to-date labor license and ESIC.
Okay.
Now, your lordship, may I just point out one thing?
Now let us, we'll point out. Now let us go to the rejection.
Page 307.
Page
307.
307. Page 307.
Annexure 6. Has the lordship got it?
Non-responsive as the labor license is valid for Kamrup district only.
Yes.
Okay,
Yes, your lordship.
Kamrup district only. Now, so as the provision of Contract Labor Act.
Yes, your lordship. If your lordship
Contract Labor Act.
takes up the Contract Labor Regulation Act 1970. Okay, no?
Contract labor,
Your lordship,
which is the provision of issuance of certificate.
your lordship, I'll just like to read from.
No, we'll,
definition. Okay.
we'll hear you. Just
Okay.
we want to understand.
Section
See,
12.
your whole case is that this license is that there is irrespective of this license that I'm Kamrup or Shivsagar, there is no meaning of that. Substantially complied, and not only me, others have also have the same certificate. Therefore, this is a discrimination.
Right.
This case will take 5 minutes to 10 minutes.
Yes, your
Yes.
lordship. Number
Let us not waste time.
yes, your
Yes,
lordship.
come to
I'm obliged, your lordship. Section 12, licensings of the contractor,
section 12.
licensing of contractors,
Just a minute.
page 9.
Section
এখানে
12, licensing of contract. Okay.
now your lordship will also look at section 14, revocation.
No,
I'll
just
come back to that.
we'll go to first 12.
Yes,
Then we'll go to 40.
yes.
Yes.
With effect from the such date as the appropriate government may by notification in the official gazette appoint no contractor to whom this act applies shall undertake or execute any work through contract labor except under in accordance with a license issued in that behalf by the licensing authority.
Okay. Now, section 14.
Section 14 empowers for revocation and suspension of the amendment of the licenses. It says that the license which has been issued to a contractor can be suspended or can be revoked if it does not follows the criteria as required under the provision of this act.
Where this who issues this license?
The labor commissioner and the-
Labor department is a party here.
no, your lordship. Now, section 20, it speaks of the liability of the principal employers in certain cases.
Section
20. That is at page 11 down below, your lordship. If any amenity required to be provided under section 16 and 17, section 18 or section 19 for the benefit of the contract labor employed in an establishment is not provided by the contractor within the times prescribed, therefore, such amenity shall be provided by the principal employer within such time as may be prescribed.
yes.
Now, section 21, page 23, your lordship.
Okay.
Every license by a contractor for the grant of license shall be made specified in sub-rule 1 of section 17 of rule 17 in such and such form. Number 2, every application for the grant of a license shall be accompanied by uploading a copy of the certificate of the principal employer in form 3. I'll pause there for a moment. This is in respect of central obtaining a labor license from the Central Labor Commissioner.
Is there any form of license, any
Yes,
appendix?
yes,
Where is
yes,
that?
your lordship, will come to that. By the way,
Rules.
yes. Now, section 35 of this act empowers the state government to frame the rules. And accordingly, the rules have been framed by the state of Assam.
And where is the form of certificate?
Your lordship, it's at the application as the section, relevant section is at page 284.
Rule.
Yes, your lordship.
What?
Rule 21,
Rule 21.
284. It's on the left side, your lordship, the page number.
Rule to page.
Page 284. May I read, your lordship?
Just a minute. Yes.
Every application by a contractor for grant of license shall be made in triplicate in form 4 to the licensing officer of the area in which the establishment in relation to which he is a contractor is located. That's clause 1, your lordship, rule 21(1). And 21(2) says, every application for grant of license shall be accompanied by a certificate by the principal employer in form 5 to the effect that application has been employed by him as a contractor in relation to his establishment and that he undertakes to be bound by all the provisions of the act and the rules made thereunder insofar as the provisions are applicable to him as principal employer in respect of the employment of contract labor by the applicant.
Okay.
Now your lordship will kindly turn to page 308.
Rule. Rule.
That form 4 and form 5.
Three zero eight.
308 is form 4 and 309 is form 5. I'll read first form 5, your lordship. Has the lordship got it?
Yes.
This form has to be issued to me by the principal employer. That is the department wherein I am praying for enlisting of me as a contractor. Certified that I have engaged / proposed to engage the applicant, the name of the contractor, as a contractor in my establishment. I undertake to bound by all the provisions of the Contract Labor Regulation and Abolition Act 1970 and Contract Labor Regulation and Abolition Act Assam Rules 1971 in respect of employment of contract labor by the applicant in my establishment. Your lordship, now form 6 is at page 311. They issue this form.
Form
6. Is on the right hand side, your lordship. Number one, license is hereby granted to such under section 12(1) of the contract labor
So your
regulation.
argument that this question will come after the contract is awarded, not
Uh,
before.
I'll just like to modify it, Your Lordship, permits me. Yes, Your Lordship is correct. In view of the clauses as said in Form 4. But what is the basic purpose of this labor license?
No, that we understand.
Yes.
Will that there is no quarrel. Why
No.
it is required that contract labor is clear. Let us not go to that.
Yes, Your
What
Lordship.
is your argument on this?
Your Lordship, my
As regards issuance of license for an area.
Your Lordship, when I want to enlist myself, I'll just take few minutes, Your Lordship. When I want to enlist myself in says ABC department, I'll have to go to the department. That principal employer is the director. Principal employer has been defined in this act as well as in the bid documents. So principal employer is the director. The director issues me with a Form 5. I go to the labor department of that area,
Of which area?
of the area where it is situated. That's what clause 21
Or
says.
situated whose
Of the principal employers, Your
Ah.
Lordship. So I'll go to that area. I give him the Form 5. He issues me a Form 6. It's an acknowledgement that I have not violated any norms of the labor laws. And therefore, I am qualified to be empaneled there. Now, there is a reason behind it. If I have been blacklisted by the labor department or the labor department does not issue me with any the certificate, then they will not enlist me. Because even if I get enlisted, they will not be able to award me any works. I will not be able to carry it then. So that's the basic idea. And the very core issue is that I have not been blacklisted. I am been registered in the department. The only issue which they are keeping it right now is that I am not registered in the entire state of Assam or Sibsagar district. I am only registered in the Kamrup Metro. If your Lordship kindly. So that is the basic contention they have raised. And my humble submission will be that the principal employer is situated at Kamrup Metro. It is the directorate office which issues all the tender works. I am registered with the directorate office. I am ready to, I am an able person to undertake any work issued by the directorate office. If that not would have been the case, the director would have rejected my application for enlistment. He should have said me because he doesn't know for which area he'll issue the work order.
Yes.
That's basic the contention number one. Secondly, Your Lordship, I have complied with the essential terms of the contract.
No, we'll come to the essential terms later on. Now, let us have some interaction with the
Okay, Your Lordship.
employer. Yes, what is your case?
Lordship. First, Lordship, I'm not on my affidavit. Firstly, Lordship, the bid document, page number 55. Lordship.
Yes.
Again, that subclause Roman 3,
Page.
55 of the repetition, Lordship.
Yes. $55 of the repetition. Okay.
The first, in the first,
Just a
top
minute.
of the Roman 3.
Just a minute, please. Yes.
EPF with up-to-date payment channel along with up-to-date labor license and ESI. And Lordship,
Your rejection, ground of rejection is labor license.
our ground of rejection is that he has the labor license of only Kamrup Metro.
Understand, that is your
That
ground.
is our issue. As we have one criteria in the bid document at page number 50, Lordship, that is 30.2.
30.2.
30.2 of the bid document,
Just a minute.
page number 50.
Page number 50.
50.
Yes.
I read number
Clause 30.2.
30.2.
Yes.
The bid evaluation committee may request the bidder to submit necessary information and documents which are historical in nature like audited statement of account, tax clearance certificate, PAN, etc., within a reasonable period of time. Failure of the bidder to comply with the request within the given time shall result in the rejection of the bid.
Hmm.
That is clearly, here it is clearly mentioned that we have then verify, scrutinize the historical document.
Hmm.
So we have verified the allegation from the petitioner said that they have not given a chance to give the second rectification, which was given to respondent number 6 and 7.
Hmm.
They have given another license and they were asked to submit their license for the Animal Husbandry and Veterinary Department within 3 days, and he has not given that chance.
Hmm.
That is their contention. Lordship, when we have searched for the historical document, we have found historical document, we have already, we said that they have given the complete set of their document. There is no missing document in their tender notice, Lordship, there. So we have not asked them for resubmitting any document because they have not given any incorrect document. They had the only criteria is that their license is valid only for Kamrup Metro. And the petitioner,
Respondent.
the respondent, 5 is okay, 5 is okay, 6 and 7, for 6 and 7, they have given a wrong document. One document is missing. Their documents are missing, which we search in our historical document as we have seen that they have already all over license for all over Assam in Animal Husbandry and Veterinary Department. Lordship, now
What is those
kindly
historical
come to
document? What are these historical document you have sought?
historical document we have sought for the labor license because without the registration in the without the registration in the Animal Husbandry and Veterinary Department, they can enter in the e-portal.
So therefore, whole case boils down,
Hmm.
what is the mandate of law and the rules for issuance of a certificate? Okay,
Lordship.
let us see that first. Just let us see whether the condition can be implemented so far limiting to labor license,
For a specific
for labor license prior to even issuance of a work order.
is in the bid document that we have to
No,
submit.
suppose if
Lordship.
bid documents, when a license is issued, the rule, what the rule says, let us see the rule says, let us section see rule 21, let us see rule 21.
Right with Form 4.
Rule 21, Lordship,
Hmm.
application for a license.
Okay. Who will give the license, to whom license will be given, under what condition? Let us see. Application for license, read it.
Number 1, every application by a contractor for the grant of a license shall be made in triplicate
In form
Form
4.
4.
Okay, these are no quarrel on that. Form 4, okay. To whom?
to the licensing officer of the area
Hmm.
in which the establishment, licensing of the area in which the establishment, Lordship,
Establishment of whose establishment?
in which the establishment,
Hmm.
in this case, Lordship, the establishment is the issuing authority, Lordship. Sipsagar, here, in our case, it is Sipsagar, Lordship.
No. Let us understand. What is the mandate of section 21? Section 21 says that a contractor will have to make an application in form 4. Number 1. To whom? To the licensing officer of the area which the establishment in relation to which he is a contractor is located. Okay? So, the establishment of the contractor as per your thing is located in Sipsagar.
Sipsagar.
Okay? So, it is to be issued by Sipsagar. Now, clause 2. Every application for the grant of license shall be accompanied by a certificate of the principal employer in form
Form
to
5.
the effect that the applicant has been employed by him as a contractor in relation to his establishment and that he undertakes to be bound by all so and so, so and so. So, this without clause 2, clause 1 cannot be satisfied. Without clause 2, clause 3 cannot be satisfied. And when clause 2 will be satisfied? When somebody is awarded with the contract.
I just clarify, my lord.
Yes.
My lord, permits, my lord.
Mm.
I am not taking the opportunity of my friend. I'll just clarify. My lord, this
No, no,
clause.
we are open. Just whatever we have
No,
read.
only since I'll just try to clarify, my lord, lordship's query, my lord. Para 2,
Hmm.
rule, sub-rule 2 is with regard to form 5,
Hmm.
which the principal employer will issue after the award of the contract.
Understand?
So what the department here is doing is that, my lord, they are considering previous certificate.
Okay, previous certificate. So
The
therefore,
time of register, because they have got a.
suppose just before,
Yes,
what we
yes,
are saying
yes.
is clause 2 will not be applicable at this stage. The valid contractor whose tender is accepted, then only the employer will issue a form 5. We accepted. Now you want the previous license.
My lord, this previous license is like, they have started a system of registering the contractors. So while registering, they have to submit this
License.
electricity license,
Anything,
labor
anything,
license,
like
all the
all
license.
the license.
So while registering, they are getting the license. Now while issuing the tender, they are asking the contractors that whatever license, as per the NIT, whatever license you have
You give
got,
her, give it to us.
with regard to the, as per rule, if we go 21, 1, it has to be with regard to the district where the work is to be executed.
Okay,
21, 1.
okay, understand.
So this clause 2 will not be relevant in the present facts of the case, my lord. That is
21 is not relevant.
21, 2.
Okay,
1 is relevant.
let us forget about 2 for the time being. You show us every application by a contractor for grant of license shall be made in triplicate in form 4
Yes.
to the licensing officer of the area in which the establishment in which the contractor is located.
Yes.
Contractor is in relation to which
Contractor, comma, my lord.
in relation to which
Lordship.
no, comma,
Yes.
establishment in relation to which the contractor.
He is the contractor. He is located. That
So
means
he
the
must be a contractor.
he must be a contractor.
Contractor of whom? Of the, according to in the case, contractor of Jorhat division. Is not it?
No. My lord, that will be another discrimination, my lord. That Guwahati people are not
Therefore,
allowing.
therefore,
No, what the, my lord, I'll just place the rule. To the licensing officer of the area
Hmm.
in which the establishment,
Hmm.
or she will pause here for a moment,
uh,
is located.
Hmm.
In relation to which he is a contractor, fine. He have participated in the tender process, he is a contractor.
Hmm.
But issue herein is that the main question is, what is establishment?
Hmm.
Whether it is the district wherein the work is to be executed, or it is Kamrup. In the,
we will not go to that also for the time being. For the time being, we are asking you now.
ultimately, this question will come, my lord. End of the day, this question will come.
That is what.
But what is the meaning of this?
Let us not wait till end of the day. Let us open the day with this answer. If this answer is given, then whether this tender clause is even
My lord, the
implicated.
question is that he has got a license for Kamrup district.
Okay.
He doesn't have any license for Sibsagar, my lord.
Yes.
It's an admitted factual position.
No difficulty on
Other
that.
tenderers, my lord, two of the tenderers, in fact, other tenderers, they have submitted license for all over state of Assam.
Hmm.
They have got license.
Hmm.
Now we'll have to understand what does this word establishment mean.
Before that, we have to understand whether where is the provision where license is given for whole of state. So as the provision.
You know, that is issued by the labor department.
No,
Yes.
labor department, we'll forget about labor department. We want to forget about
What
affidavit.
they say, I'm just expressing, my lord, what they say.
Whatever, we'll go to them later on. What we want to know is, let us show the provision of the act and rules. What is the procedure to issue a labor license? And who is the authority and how this labor license are issued? Show us first that.
My lord, perhaps subject to correction, my lord, instead of going into the procedure of issuance of labor license, if we come to the conclusion that whether a labor license of that particular district wherein the work is to be executed is required or not, that will suffice the entire purpose. So Lordship will kindly take up the rules.
No, we are
Yes,
coming to
yes,
that.
I'm sorry.
I'm coming to that.
Yes, yes.
So to come to that provision, we must know that whether any provision of issuing a license for whole of state, in as much as Rule 21 says it is to the establishment of the area licensing officer. So suppose a person is given license in Jorhat, so he will be debarred in participating in any district either.
No, it
Or
is
there will
optional.
be there will be a provision of giving license for whole of Assam, which is being given to respondent number 6 and 7. So show us that provision.
What department is doing, the labor commissioner is issuing license for, as per the affidavit of the respondent.
Mr. Das, I am asking you, show me the provision of law.
Lord, I haven't found any provision.
Any provision.
Here, but the
That-
process they are following is that.
What they process, their
Le-
process may be illegal.
No,
We are not going to comment on that. We'll here to see whether there is any scope under the act to issue him a license. If somebody is given illegally, we are not concerned with that.
no. The thing is that, my lord, whether the main question is whether you are required to submit an labor license pertaining to that particular district or not.
See, I'm little bit slow.
I'm sorry,
So to go to that extent, we want to understand the law first.
Lordship, correct.
What is the provision of law of issuance under contract and the rules regarding the issuance of a license, which you are insisting? As per tender condition, give us this license. We want to know what are the provision where a license is issued, section 35. Now we want to know who is the authority and whether it is a license by in respect of an area, in respect of state, or in respect of a in
The
respect to
labor
what?
department is issuing license district wise, all Assam also. The
Mr. Das, what they are doing, we are not concerned for the time being. What we want to know, what law prescribes. You tell us that. We'll go to the labor department later on. Suppose labor department is issuing a license in violation of, in favor of your client. We are not going to say that this is an illegal license. In this case, we are not going, this is
Yes.
not the issue before us.
but as per the
Issue
rule,
before us is
Yes.
that whether his license given into a specific area, beyond that, there is any scope for issuance a license under the act for whole of Assam, or therefore we want to know the procedure of issuance of license and the jurisdictional authority and the form of license. That's why we have specifically put 3 questions
yes,
that he has answered under 21, 22 and section 35.
yes, 21 is the licensing officer, my lord, of the area.
Okay.
Absolutely clear.
So therefore, a person will to apply for a license in a regional basis, area basis. Area basis. And so what is the criteria on the what basis? Let us see the form 4.
These are all previous licenses, my lord, considered by the department.
So if it is a previous license, you will have to issue a license in terms of 2 ultimately. Subsection sub-rule 2 of 21.
Two, in respect to previous license
Let us
also,
see the form 4.
two will
Form
come,
four.
my lord.
Page
Form 4.
308, your lordship. Clause 4 is the reply to the query put by your lordship.
Clause
4 in the page,
308.
yes,
Page 308.
your lordship.
Okay, 308.
Clause 4, particulars of the contract labor, nature of the work in which contract labor is employed or is to be employed in the establishment.
Kindly come to clause 3.
Particulars of establishment where contract labor is to be employed.
So always it is a license work specific.
Work specific.
So if it is work specific, what is the relevance of issued in Jorhat or Sibsagar? Because he might not have worked in Sibsagar any time in his life.
No, he never applied for Sibsagar.
No, he has not worked because he cannot apply until and unless he has a work in
Yes.
Sibsagar.
No. Lordship will kindly appreciate.
Kindly read 3, clause 3.
Issue is not that whether he can apply or not. When the NIT was published, my lord, the licenses are already there. So he has,
Licenses are there in respect of what?
we are concerned with Rule 21 establishment, my lord.
Huh?
Rule
Rule 21 is relatable to form 4. a license under Rule 21, one will be given if he satisfied Rule Form 4. See in the Form 4. Suppose a person has never worked in Shivsagar with any establishment. So you want to
Milord-
say when in case of a Shivsagar work, he's thrown out from the work.
No, that is not, Milord, I'll just rephrase the thing, Milord.
No,
Rule
before you
20
rephrase, let us read the Form 4.
Yes, ma'am.
You read it.
Yes.
Yeah,
Uh,
name and address of the
Contractor, including the father's name,
Okay,
date
fine.
of birth, age, particulars of the establishment where contract labor is to be
Is
employed.
to be very important. Is to be.
That means this is after the contract is awarded.
Therefore, no, license is issued when? So as the provision of labor license issuance before contract is awarded.
That is why I am saying that these are all previous license.
Where is that provision of previous license? Under the act or rules?
It is the part, Lordship will kindly appreciate, the NIT provides that their parties have to submit the labor license. NIT, as per the terms of the NIT. So whatever labor license, since the work is pertaining to Shivsagar, like other parties, they have submitted all over Assam. So they were qualified.
So therefore, your
So
argument is
since they have submitted all over Assam, so they qualified. So the petitioner, he cannot be technically qualified.
because
if I
he
have
has no
understood,
license for whole of Assam.
either
has
whole
only
of Assam or Shivsagar.
He's not having, he's only on
that is-
Kamdev. So according to you,
in fact, till today, not only that, prior to the submission of bid, even thereafter also, as per the affidavit, they have renewed for Kamrup only.
That's a wrong statement. He doesn't know.
take your seat.
Ex-
Take your seat, Mr.
Even-
We do not
even-
want any excitement in the court, huh?
Even if
This
you-
dumping thing we do not like. Yes.
Yeah, I'm sorry, Milord. Even if we don't consider renewal part, as my brother says, Milord, he doesn't have a license for all over Assam or Shivsagar. By Kamrup, he cannot get qualified because Rule 21 is absolutely clear. Who is the licensing authority? Who will issue license? Let us not go into that aspect of the matter. But the 21 is absolutely clear with regard to the establishment. And what is establishment? Your lordships will understand from the various provisions in the rules, Milord. Lordship will kindly take,
Tell us.
because this establishment has to understand rule, kindly, my lord, 25. Page 288, my lord, will come.
Page
288.
Okay.
His whole argument is that establishment is directorate in the writ petition.
His argument may be wrong.
Establishment is directorate.
His argument may be wrong.
No, if his argument is wrong, writ petition is to be dismissed, my lord.
But we cannot shut our eyes regarding your argument also.
No, lordship will definitely, lordship will
You are
put
in a
query-
read court. You are in a read court.
Yes, yes.
Will jealously protect persons right under Article 14.
True, my lord.
He might not have a good understanding of law.
True, my lord. Absolutely correct. Even going by that, my lord, if your lordships kindly come to page 288.
Yes.
What is this establishment in Rule 21(1)? In every establishment where 20 or more rule, my lord, it is Rule 25, 6A.
6A. 5A. It is up to 5A.
Next page, my lord.
6A.
Page 288. In every establishment where 20 or more women are ordinarily employed at contract labor, there shall be provided 2 rooms of reasonable dimensions for the use of their children under the age of 6 years. Meaning thereby, in every establishment. That means this is an establishment which is to be situated at the place of construction.
Of course.
Lordship is clear about
Yes,
that.
clear.
That it has to be Shivsagar.
Yes, Shivsagar.
Establishment is Shivsagar.
Yes, license is to be issued.
Either
and
all Assam.
verification, all Assam will come later on. Verification so far relatable to the contract in question.
Yes.
The employer will say, I have employed it, I will meticulously see whether he has done it. Contractor will certify that we have given him a work and you can issue a license, he is having this. Then a license will be issued to a specific work. Therefore, I want to have a satisfaction that there can be a license without a specific work, relatable to a specific work.
Here, my lord, NIT, from the NIT, what I have understood is that terms of the NIT, they wanted this labor license from the contractors.
Level of the contractors.
So
This will relate to
since the work is,
this will relate to previous license.
these are
They
not-
cannot give a license from Shivsagar,
because contract is not awarded.
not awarded.
So that is why.
So therefore, there cannot be a license as on date, which is a tender conditions. Therefore, the tender condition is to be read that this is a previous license, and
Yes.
previous license cannot be either for a region or for a state. It is under the act and rule. It should be relatable to an work and or to an
My
establishment.
lord, the contractors, my lord, the contractors, they have already got the respondent number 6 and 7. Lordship will kindly appreciate one thing.
You want to go further.
No, what I am trying to.
You want to go further that from where they have got the license
No. That
and
is-
under what provision authority
No,
of law.
my lords, that is not required to go, my lord.
That not
What,
required to.
what,
We'll take that in a given case when it issue comes.
no, what happened here is that, my lord, the labor licenses were submitted, my lord. The NIT wanted labor license. Now, in the labor department, my lord, they have got a portal. Nowadays, my lord, everything is online. So it is the choice of the contractor. Options come, my lord, district-wise option come, all Assam also come. So it is the choice of the contractor where for my lord, which district he wants to have a license.
So as that provision or under the act.
Uh,
What they do in computer, we are in a sitting in a courts of law. We are not concerned what executives are doing. We are concerned with what is the procedure prescribed under the act and rule, and whether a license can be granted in this manner. If can be granted, if he is not having his out of the court. If there is in the law
Look,
act and rules, there is no prescription, but somebody has obtained somehow. Will not go into that. Therefore, will put him a burden that no, if somebody can take this license, why not you? So as the provision of law. That's all. That's why I'm asking from the first moment. So as the prescription of the act and rules, how and when rule can be issued. Subject to what you say, all this 35, 21, 22, Form 4 clearly says the labor license, contract labor license can only be issued when there is an employer and there is an employee. Employee means a contractor. Here, the employee is not arisen, and therefore it will be relatable to a previous contract. When it is a previous contract,
previous contract, previous
license.
license.
Previous license.
Yes.
No, therefore, previous license also can be under the acts and rules, can be only for an work. Suppose a person has never worked in Shivsagar district or Jorhat district. He has worked in Dhubri for years. So his previous license will be relatable to Dhubri, to a specific work, construction of Dhubri hospital.
No, I look.
Can you reject on this flimsy ground a technical bid?
All the parties, because why I'm saying so, because it is for the contractor to get the license. So
it is the contractor to get the license in
contractor-
terms of the acts and rules.
same contractor, my lord, while working another project in Kasar, he submitted all Assam license.
So therefore, you are saying that if a person dehones the prescription of rules and act, can obtain a license, you also obtain, then otherwise will disqualify you. This is your argument.
No, my argument is that, my lord, we are not required to go how a license is issued. My submission is that, my lord,
no.
It is for Shivsagar. Lordship will kindly appreciate. The place of establishment is Shivsagar, and the parties, the contractor intending bidder has to give a license all over Assam or district wise, or for the district. He doesn't have that license, my lord. Had he submitted all over Assam, because Labor Department is issuing license.
I agreed. So therefore, intention is that those who have worked only in Shivsagar or in whole of Assam only be entitled for license and entitled
And
for the.
admitted factual position is that the petitioner doesn't have the
Doesn't have, no, no
license
problem.
for
There is no dispute.
license for, he has license only for Kamrup.
Yes.
And same petitioner, while working in Kasar, he submitted all India, all Assam license. So it cannot be construed, it cannot be an argument that I was not aware that for the district Sibsagar, I need a license from this labor officer Sibsagar, Milord. Because all the parties, they have submitted all Assam license, Milord. And labor department is
That
issuing
is
all
why I
Assam
want to
license.
know the power of the authority to issue license all Assam without any rules, please show us.
That has to be clear, because I have searched the rule, Milord. Rule only provides for licensing officer of the area. But how labor department is, Milord, giving license for all over Assam, that procedure has to be, Milord, from the labor department will be able to clarify. But otherwise, Milord, it's an admitted factual position that the bidders who are qualified, Milord, they have jurisdiction over all over Assam, and the petitioner doesn't have. And it is the choice of the employer
That's all.
what license he wants to have.
That's all. Dictate the order.
Lordship, may I place some?
Yes, yes. Judgments, please.
Perhaps Lordship is aware of Utkal. Here also, my lord, labor license was an issue. I'll just take the relevant paragraphs. my lord.
Paragraph.
Para 15. Because all the previous judgment are discussed here.
Then which paragraph 15?
Para 15, my lord.
Okay.
Equally, this court in Lordship, equally, this court in Afcon Infrastructure Limited versus Nagpur Metro Rail Corporation Limited has laid down. We must reiterate the words of caution that this court has stated right from the time when Ramana Dayaram Sethi and International Airport Authority of India was decided almost 40 years ago, namely that the words used in the tender document cannot be ignored or treated as redundant or superfluous. They must be given meaning to their necessary significance. In this context, the use of the word metro in clause so and so of the document and its connotation in ordinary parlance cannot be overlooked. Para 15. We may add that the owner of or the employer of a project having authored the tender document is the best person to understand and appreciate its requirements and interpret its document. The Constitutional Court must defer to this understanding and appreciation of the tender documents unless there are malafide or perversity in the understanding or appreciation or in the application of the terms of the tender conditions. This is important, my lord.
Yes.
It is possible that the owner or the employer of a project may give an interpretation to the tender document that is not acceptable to the Constitutional Court, but by itself is not a reason for interfering with the interpretation given, my lord.
No doubt about that.
So if the employer wants all Assam license, then my lord, there cannot be any quarrel over that. Now, my lord, para 16.
Provided it is suppose it is not permissible under law. Can you insist upon a tenderer to that? No, you'll have to.
It is
If
not his
somebody has-
case. My lord, it is not his case in the writ petition that the license were procured illegally. It is not, it is
No,
not a.
he's not case of illegally. His case is that this is my
His case
license.
is that, his case is that, my lord, no opportunity was given to him uh, to submit documents, my lord. That is his case. And others were given opportunity to submit updated document, my lord. It is not his case that he was having a license of All Assam or Sibsagar, my lord. Also, will kindly come para 16. Further, in the recent judgment in Lordship's got, my lord.
Ah.
Further, in the recent judgment in Silpi Constructions Contractor versus Union of India, this court held as follows. The essence of the law laid down in the judgment referred to above is the exercise of restraint and caution, the need for overwhelming public interest to justify judicial intervention in the matters of contract involving the state instrumentalities. The decision is totally arbitrary or unreasonable. The court does not sit like a court of appeal over the appropriate authority. This is important. The court must realize that the authority floating the tender is the base judge of its requirement, and therefore the court's interference should be minimal. The authority which floats the contract or tender and has authored the tender document is the base judge as to how the documents have to be interpreted. If two interpretations are possible, then the interpretation of the author must be accepted. The court will only interfere to prevent arbitrariness, irrationality, bias, malafide, or perversity. Now, para 17, the High Court has not adverted to any of these decisions, and the second guessing of the authority's requirement of a license under the Contract Labour Act has clearly overstepped the bounds of the judicial review in such matters. So, is it your case that you have got a license of all over Assam? You don't come into the zone of consideration. You don't come into the zone of consideration for determination of your eligibility. It is not your case that the Labor Department is issuing license all over Assam illegally. It is your choice to get a license. You cannot get a work at Sibsagar by producing a license in Kamrup.
Where is the license of the
Yes, Lordship will kindly
license
see.
of the other your client's license? Yes.
My first of all, Lordship will see petitioner's
No,
license.
they have seen. We want to see your license.
Valid for Kamrup only.
That is no dispute on that.
No. My lord, page 338 of the writ petition. He chooses not to apply all over Assam. Then, my lord, the other persons, if your lordships kindly take the page number,
This page 338.
338 is my, my lord.
This is relatable to
Friends,
friends.
number 5.
Please read the clause 2.
Clause 2. Yes. The license is for doing the work, construction, earthwork, repairing, supply, etc. in the establishment of Animal Husbandry Veterinary Department, Assam, and PWD building and PWD roads, care of so and so, Guwahati, Kamrup Metro, Assam. Then license will remain valid since so and so. Maximum number of contract labor proposed to be employed in the establishment, 10 number, valid for all over Assam and only for the purpose mentioned in this certificate. So it is for all over Assam.
All Assam for what? For execution of the construction, artwork, repairing, supply.
Yes, Lord, because
And
this is
issued under section 12(1).
Yes, my lord. Under section 12(1).
Yes, proceed.
So, my lord, This all over Assam license they have accepted. An employer is the obey judge that whose license they won. And as per the rule 21(1) also, maybe rule.
Can you say that employer will be best charged to accept the matriculation certificate required for a master degree certificate?
I'm not saying so. But my contention, my submission is that, Milord, had they have
Judge must have the rationality and reasonable nexus between the object sought to be achieved and the document required. That's all. They may interpret in their way, no doubt about this.
Yeah. They
But
want
can
like
they, therefore, in Dhanam Setti and all others, it's just a perversity word is used.
so they, if the employer wants the license which covers the district Sibsagar, so how can the petitioner say that I have Kamrup, so I'll have to be allowed?
No, he cannot say until and unless that can be obtained from the department.
So he should have obtained from the
He cannot obtain under 12(1) if any other provision. That's why I'm asking any other provision.
May I just check?
You check it. Will if necessary, we'll hear you on Tuesday. No problem on it.
Yes, my lord. I'll just check.
No problem.
Because
So,
the act I
since
haven't
your
checked.
license is also 12(1). Okay, so if there is any provision which gives a power to issue a contract labor, generally, no problem on that. So you have, then we can say they have asked for a general license, not as a license for district only. So they want a general license. But if there is no provision under Act to issue a general license, and license can be issued only in respect to an work, then can you say that no, you will have to beyond the rules?
Lordship will take up Tuesday, my lord. I'll try to check and
Just
I'll.
that satisfy.
Yes, I got your lordship's point. Fine, my lord.
That is the case. If there is any provision, then he's out. This is your interpretation. That word, though you have not said anything, that will mean if you have interpreted it to be a general license provided under this act, very well, then he's out. And if you say that then other aspect will come, whether he has been given a chance to obtain such a general license or not, this will come on later on. First fundamental point is that whether he can be rejected for one, you have said you are want of license. You don't have the valid license. That is why you have been rejected. This is the fundamental issue.
Yes.
So we'll have to see whether there can be a license as you have interpreted. A general license.
All over.
If that is permissible, you are very well within your parameters. Law is well settled. No doubt about this. Throw him out. No problem.
In the meantime, may I make a small prayer till
Yes.
Tuesday or Thursday, my lord, whatever date you're. Can the state be asked from the labor department? Because I am not privy, or I don't think my friend will be also privy to the functioning of the labor
That you
department.
can do.
Rule is there, my lord.
There is no problem.
I'll
If
check.
rule is there,
I'll
you
check.
have any executive instruction. What you have your
That is
instruction
the
from your
problem.
client.
Lord. Rule is there. There may be executive instructions or some.
But can there be an executive instruction in derogation of the rule? That
No, whether it is in derogation or in supplement, that your lordship will kindly consider. But perhaps, my lord, my humble prayer that the state may be asked from the labor department.
who is representing labor department?
Labor department Mr. R. Dhorni.
Okay, we'll pass an order adjourning this matter. But we are also anxious to take this matter because it's a public project.
Yes.
It's a public project. Either way, it should not be stalled. It will
It should not be
escalate the
delayed. At
delayed.
least.
Should not be-
Whatever be the outcome, my lord, it
outcome
should not be delayed.
should not be delayed. That is our concern.
Lordship, instead of Tuesday, can it be on Wednesday or Thursday, your lordship? Tuesday, I have a part-heard hearing at court number 1, so it might take some time, your
We'll
lordship.
hear you later. Huh? You have concluded your argument. We just want to hear him only.
Lordship will take up on Thursday, my lord, no problem. But the lordship will
They have
kindly.
expressed some urgency. They wanted to have it day before yesterday itself. Yes.
The urgency is on my part also, my lord. I have been, because financial beats are open, I have been declared as L1. So, GA Assam. My lord, GA Assam appears for the labor department. Because this has to be clarified, my lord. I have searched for the documents, whether I can get, but
You just go through the scheme of the act and rule.
I'll try to satisfy your lordships, whatever be, my lord, whether it's come in my favor or whatever, I'll place the law before your lordships. But in the
So
meantime,
his projection was something different, but we cannot, this is the issue, very vital
his
issue.
case is totally different.
His projection is something different. He has not gone through all this. He said that, please give me a chance to get a license like others.
Your Lordship, in fact, I have projected my case that I have substantially complied
What substance, what compliance?
as per the terms and conditions.
You
of the-
say that where is the, there is, this is the compliance, nothing more. It's not substantially. This is the compliance.
Yes,
That should
sir.
be your argument.
That-
You are saying
that's-
substantially. What substantially?
In fact, Your Lordship, in para 11 and 14, I have categorically stated that. I'm sorry.
Anyway,
As per the.
hard in part, list this matter for further hearing on
Thursday, my lord.
Thursday. Give a date.
Next.
In the meantime, Lordship will kindly ask this.
I'll also go through details, these rules.
Yes, let
I'm
the-
keeping this.
Your Lordship.
Contract labor also keep a copy in the chamber.
Lordship will ask the state government.
Uh,
to clarify.
That may delay this process,
No, it will
implement
not
these
delay,
that.
my lord. It will not delay. It's a one.
This court
only-
request, Mr. Can you call Mr. Dina today itself?
Yes, my lord. I'll just call.
You call him so that by Wednesday yes, Mr. Nath is there.
I am lucky.
You are lucky.
I am not lucky. He is also lucky, my lord.
Mr. Nath, we are in a midst of a problem. There is a tender by one of the instrumentalities of the state, which it says that you will have to give a license under Contract Labor Regulation and Abolition Act. Okay. Now, under the act, there are some rules are framed. Procedure of giving a license is prescribed under the rules framed by the state. Prima facie, this is prima facie. Prima facie, this court is of the view that license can be granted for contract labor once the employer or the state, instrumentality of the state, certifies that yes, we have given him the work, he is having this kind of satisfaction there, you can issue a license for this work and will ensure. The state will have to give an undertaking under sub-rule 2 of Rule 21 that she will ensure that he does it. These are the requirement, some houses for women, these, that, what not. So, 2 certificates are given. So, prima facie view of this court is that labor license can be granted work specific, project specific by the officer who is locally situated. The object is also there so that he can see the implementation of the license. That's why the local, where the project is done. Now, here in this case, all the tenderer has given a license, general license. It is applicable all over Assam by the authority under 12(1). We do not see any provision or power to give such a license, whole of Assam. Because who will implement that? Suppose this license is issued in Kamrup, a project is taken in Dhubri. Who will implement that project? That it is been, because there will be inspection and all. So they have issued a license. Now tender is rejected on the ground that you don't have a license relatable to Sibsagar because work is at Sibsagar. Sibsagar, suppose a person is not working in the Sibsagar, any work he has not executed. He cannot have a license in Sibsagar in terms of 12(1). So if he cannot have, can he produce a license for relating to the Sibsagar? Now comes, others have issued license for whole of Assam. Now we want to know under what is the provision when you have issued a license for whole of Assam.
The Assistant Labor Commissioner
Uh,
of the concerned district,
Hmm.
he used to give the license. So far.
that is the mandate of Rule 12(1). But here, Kamrup has given a license for whole of Assam. Where is that provision? So as then he's out from the court.
That
Do you understand my point?
I understand, my lord. I have got your lordship's point. Yes.
Because otherwise, if
We are
allow-
also not at fault, my lord. We
No,
apply for a license.
No, understand.
You have got a portal wherein you have options.
So
for all
therefore,
over Assam and
these
district-wise.
conditions shall not even be essential condition, which cannot be implemented. Only this condition, prima facie view, which cannot be implemented until you need a license that to see that whether you have obtained such a kind of license in previously, or is there any violation or something like that. So they can verify, suppose his license is in Sibsagar or Lakhimpur. He shows this Lakhimpur, they will verify that this person, did they execute and is there any violation? Labor commissioner may give a report, yes or no. Maybe for that purpose, we do not know.
Milord.
But if you say that no, any license will do. If we approve this thing,
No,
then
any
it will-
license will not do. It has to cover that particular district.
district and general.
Whatever manner you give license all over Assam, all over India, Milord, whatever license,
So
but
all over,
it
if you,
has
if
to,
you if you say all over Assam, now who will implement all over Assam license?
that's a different thing.
No, we'll have to,
Yes, yes.
as a court of judicial review, we'll
Correct.
have to
Your
keep
lordship is
open
correct.
everything up.
But the particular district has to be included within that license. That is the mandate of law.
Yes, so that
And
license,
whoever will be
suppose,
the issuing authority.
suppose tomorrow you are awarded the work.
Yes.
Do you propose to say that you can execute the work on the basis of your license previously issued? According to this court, no. The employer have to give a form 5, form 6 to you. You will have to file an application under form 4. Then he will have to give a certification under form 5. Then only a license will be given that yes, for this work, you will have to do this. And that is to be given by whom? By the Sibsagar. You might have a license for Assam.
Subsequent one.
Subsequent one. You'll
Yes.
have to. So if subsequent one is required, what is the meaning of previous license, state of Assam? Show us any provision, state of Assam. That is what we want your assistance, Mr. Nath.
Throughout the state of Assam, it is not within my knowledge, but I have to ask them. But otherwise, from the district concern, I know, but in
Yes.
case I have.
District is well, because and
That-
these
that-
licenses are issued under 12(1), saying that whole of Assam. Show us that
I
power.
have to- That I
That's-
have to verify. That I can ask the commissioner. Commissioner.
You have it. In there, you may have some is executive instruction supplementing the rule. No
Yeah,
problem.
Because some power must have,
Some must
otherwise why the directorate labor commissioner will issue a license for?
That you do not know. For many,
I don't know.
for many good reasons, there may be licenses.
I'll give him a copy of the
Huh? You give a copy to Mr. Nath. You are not a party, but we want your assistance.
I'll ask.
And
I'll take-
both brief him.
Yes, yes.
What we want, both brief him.
Yes, yes, I'll assist.
I'll-
Okay, registry to list this name, matter showing name of Mr. D. Nath, learned senior government Assam, to assist this court. So far relating to implementation of contract labor within bracket regulation and abolition bracket close Assam rules 1971. More particularly as regards rule 21, rule 21. And
12 and 20.
12 and
12.
12, rule 12, not 21, rule 12.
Lordship, the interim prayers may continue till then.
Interim order pass earlier shall continue till the next date of
My
list.
Pleasure, Lordship.
Mr. Das, I think I am successful today. I can also do that. And beat you. Yes, what is this? Yes, Mr. Dasgupta. Item 27. Yeah. Yes, who is for a petitioner?
Yeah.
Yeah. Yes.
My lord, this is a petition where I'm challenging the impugned order dated 20th December 2020. Where 17 December 2020, wherein I have been my file, I applied for a tender issued by the respondent authorities, and I was issued a termination letter along with the debarment for a period of 5 years, maximum punishment. In the termination letter, they also forfeited my termination notice. They also forfeited my performance guarantee, earnest money deposit and security deposit amounting to 3,08,93,889 rupees. My lord, the ground for the, my lord, brief facts of the case is, my lord,
So tell us, why should we interfere with the other parts, except the, consider the other parts, except the debarment?
except the
It's not a
department.
statutory contract. There is, we do not find, why should we go to the, this on concluded contract issues and termination?
My lord,
In a exercise of power under.
my lord, there is, my lord, for that, because there are the brief facts I may state, my lord. There was a tender issued by the respondent authority in November 2019, 14 November 2019, 2nd June 2020.
There are some defects in your documents according to them. And therefore, you have asked to rectification. Anyway, for whatsoever reason, your contract is terminated.
My lord, my only ground is, they took almost a year to terminate my contract. When I had submitted, they verified the document, re-verified the document submitted during a tender process. They did not verify it. As soon as they notified it to me that there is a discrepancy, that one particular document for your credential is not verified, is not correct. So you please tell us that why your contract should not be terminated and why this amount should not be forfeited. I responded to the show cause notice that yes, we checked and there was some clerical mistake. That is why wrong document has submitted.
No, that was
And
understood. You so the principle of law. Why should in a terminated contract, until and unless it was a statutory contract, why should you interfere?
Not-
Except, of course, the debarment. Debarment part, of course, will, because this is a right under violation under Article 21(19)(1)(g), of course. But so far relating to the contract liabilities, if they have committed wrong, seek from damages, loss of profit is what not.
Milord, for that, there are.
Why should we determine who is correct or how can we determine all this?
Milord, if there, Milord, I tell you for that also, Milord. When I submitted my tender document, they verified the credentials of mine. Thereafter, they issued a letter of award stating that you please submit the performance bank guarantee. After I submitted a performance bank guarantee to the amount of 2,76,70,989 rupees, plus EMD was deposited as per along with the tender document. Milord, if my credentials were not right, they could have maximum done my forfeit of my EMD. Not they further went ahead and asked me to submit the performance bank guarantee. After I submitted my performance bank guarantee and mobilized my resources.
No, they could not gather that there is some mistake on your part. When they, therefore they carried you, they discovered it at a later point of time.
Milord, they discovered it after a year.
After a year.
After a year.
So therefore, you should be excused.
No, my lord. That contract termination, the contract itself stipulates that if there is some discrepancy with regard to a document which is amenable, then I had to submit that document.
Where is that?
My lord, clause 60, page 90 of their counter affidavit, my lord, page 91.
Page?
Of their counter reply, the general condition of contracts, page 91.
91.
Page 90 starts, clause 62, 1, Roman 14.
Affidavit in opposition. Where is the affidavit? Page 91.
My lord. Relevant clauses.
Just a minute, just. Page 91, yes.
My lord, page 90 is clause 62, 114.
Page 91.
91. 91.
Clause?
Clauses on page 90, clause 62, 1.
There is no clause 62 in page 90. 1.152 financial eligibility criteria.
Page 90
This
of
is the affidavit by
affidavit.
Kirendra Nora, isn't it? Serving as a chief engineer.
It is on next.
What is the internal page? Internal page of the affidavit.
Page 72.
Internal page is 72.
71 and 72.
71 and
72 and 73.
72 and 73. Oh, just a minute. Yes, clause
62.
He is also not there.
It's there, my lord.
Huh?
Down below. at page 90, my lord, 62 1.
14.
See,
Yes, my lord.
in our paper book, page 59 starts your affidavit. If we go the continuous page.
Yes, my lord. That page number is not with me, my lord. Actually, my lord,
So you correct the pagination with the file. How can you
my lord, we have
read
not
all this?
corrected, my lord. That my lord, continuous page number is not there. That is. How does my lord? Yes, my lord. I have understood, my lord.
Page 59 starts your affidavit.
Yes, my
What is your internal page? That's why I'm asking internal page of the affidavit.
lord. 72, my lord.
72
My lord. It's at the bottom, my lord.
at the bottom.
34.
72
Page 72 internal page.
internal page. Yes.
Which is the clause?
Clause 62.
There is no clause 62 here. Here class starts is clause 33, 33.1. You correct it and we'll hear some other day. See, we cannot hear this method like this.
You know, it is their counter affidavit. I only have this copy, Lord.
No, you both of your pages are not,
My pages.
your pages should tell you with the court's page, isn't it?
You know,
Huge bunch of,
This is their counter affidavit. They filed it. If Lord may permit, may I just find it or your Lordship file it?
no, what I suggest is you complete the pagination in terms of this. Or if there is any mistake, correct this. There may be mistake from the part of registry also, I'm not saying. But this method we cannot hear because we'll have to go through different clauses.
Lord.
It's the questions I have put, it is, don't think that because so that I can get the answer.
Lord.
And therefore you have come direct to the clause. Otherwise you have, we would have started from 1942. Isn't it?
Lord.
We do not want this 1942 story, that we know. We want to know specifically what are the defects, when it was notified, and
Right.
where is the provision in respect of these defects. If you can satisfy that under the clauses, these documents can be rectified and maximum penalty is EMD. Of course, it is not, there is no bar as such that non-statutory contract, we cannot touch it. But
Right.
you'll have to be pinpointed. Don't go here and there.
I will only limit it myself to the 2-3 clauses of the contract and the tenor document.
That's all. Because you know our limitation under judicial review.
I am very much aware, and also, I have also
If
submitted.
you can show a clear case,
I will show. I will.
if
I
you
will
can
choose
show a
this-
clear case that there is a discrimination violation of Article 14, of course we will intervene.
I will show.
Not
I will
beyond
limit myself to very limited. To your lordship.
When?
Milords, if Milords, I can just we can do it at 2 o'clock. I will just verify with the.
You go through it. Go through it since he has an outstation lawyer. You go through it, but pagination of 3 of us should be the same.
Milord, I understand.
And
Milord.
if-
Otherwise, it will be very
You
difficult
go
for
through
your
it,
lordship to
which one is
comprehend.
correct?
Milord, I understand. I bow down to it for because my lords will not be able to comprehend which clause and which page I am referring to.
And
If it is
we
Milord,
don't have that luxury of that much time.
Milord. Grateful, Milord.
What is the ground of challenging a departmental proceeding?
The show cause was issued by a provision of 27C,
Hmm.
which was already amended
Hmm.
as on that. In the show cause notice, they mention a rule of voluntary abandon of company service. For voluntary abandon of company service, they need not to follow any rule compulsorily. They can pick up any rule from the company secretary rule, and if they want to do
What is your grievance?
Lordship, my grievance is that they initiated disciplinary proceeding with the voluntary abandon of companies. They continue without following any company CDA rule for procedure of major penalty. The respondent six who took the disciplinary authority for issuing the memorandum of search, at that time he did not have the required rank and designation to act as a disciplinary authority because he was in the post of with a designation of GM.
So your first ground is that the authority who initiated the proceeding was not competent.
Yes, Lordship, who issued the memorandum of charges,
He was not competent.
he was not in the post of rank and position of.
So therefore, he was
as-
not competent.
Yes, he was in the he was in the rank and position of DGM only, but that DGM was residing as the GM, so he was not in the post of rank and post of GM, Lordship.
Now, what is the present status of stage of the inquiry?
Then, Lordship, then the respondent seeks, though he impose a major penalty, he has to follow the rules of major penalty before imposing the same. So, if he want to do an inquiry by himself, then as a disciplinary authority, though he did not have the rights of disciplinary authority, he did not act as a disciplinary authority to inquiry the matter. He appointed an inquiry officer as per the
Mr. Das, you are appearing for whom?
Respondents against whom he alleged malafide him.
Okay. Yes.
as per the rule of major penalty, the inquiry officer has to be deemed to be improved as retired honorable judge or
Okay. You just show us the provisions of rule according to you which has been violated. First, let us see the provisions of rules. What was your designation at the time of initiation of the proceeding?
manager marketing.
Manager,
Marketing.
manager,
Marketing.
marketing. Okay.
So you kindly refer to the page 473.
473. of what?
Volume 2.
Yes, there is another volume. This is volume 1. Page
473.
What is this?
Lordship is absence from duty, Lordship. But in the SOCOS notice, they followed.
No, no. You are raising some question that so and so is not authorized. Okay. And this process, we want to know first what is the rule under which a proceeding can be initiated against an officer like you.
Yes.
Okay. And you show us in the rule what is the procedure and what is the violation. Because you must be aware, we cannot decide here who has committed wrong, who has not. Okay. Our inquiry in a writ proceeding should be very limited. Many issues you might have raised that Mr. Das's client is bad. This, of course, malafide exercise of power we can see. But when you have raised an issue that this person are not having the authority or he is not competent, he was a DGM, a GM is to issue. So that must be prescribed somewhere.
Yes, Lord.
That is prescribed generally under the service rule. What do you say in, yes, Mr. Deka, what do you say in service rule here in your?
It's a CDA rules, my lord. He has annexed that
CDA rules.
CDA rules.
What is this CDA rules?
It is the conduct, discipline and appeal rules for management staff.
Okay, CDA rules. So CDL rules is applicable. Where is the CDA rules?
Page 437.
437.
The difficulty is that the petition has become so bulky, my lord.
Lordship, may I please, Lordship, during the disciplinary process, I raised lots of queries because they for right from the SOCOS notice.
No, any punishment inflicted upon you.
Yes, major penalty, removal from service. Without
You have preferred an appeal also.
I already preferred appeal as well as review, but
That has also been dismissed.
Lordship, each and every
No,
page.
that has
Yes,
also
yes,
been
yes,
dismissed.
Lordship.
So therefore, you have challenged all those things here.
Each and every page, each and every document, each and every para was unspecified, random, and they did not
We'll go
mention
to that.
anything.
We'll go to that.
That is why I
So
have to submit.
therefore,
And even in the this court, they could not confirm anything, Lordship, not a single CDA rule. That is why I have to submit all those documents.
no, we'll come to that. Please show us first your show cause.
And 468, page 468.
No, please let us understand the fact. Page 468. But why this matter is listed today?
Speaks, my lord.
This matters generally we don't give preference. Generally, discipline matters we do not give preference because our scope is very limited. And we have some other important matters to be had. Anyway, since we have started it, let us see. And why this matter is listed before this bench?
Civil bench 3 matter, Justice Medhi is sitting, my lord. Typical.
But other bench is also there. Any order into that effect?
Other bench, Honorable Justice Sham is there, my lord. I think he's not there.
Any order is there?
No, there is no order. I think they are following that
original order.
original.
Where is
May
your,
I-
where
may
is your search sheet?
May I submit one thing? Subject to what he says. What I propose, let us prepare a point of argument and take out whatever is relevant documents so far as I
That's
am
what I wanted, trying to do that. Do you understand? See, if you are not the lawyer, so we will have to tell you something. In a writ court disciplinary proceeding, our power exercise of power is very limited. Okay. So you have your ground perversity, of course, we can go to it. So we must have a summary of your arguments that this is your search sheet. Okay. This is the contents, summary, contents of your search sheet. Your argument is that this person could not have issued me a search sheet or search memo. Okay. This is first violation. Why not? In terms of rule so and so, so and so. There must be, it cannot, you will say it cannot, that cannot be. You will have to say this cannot be done in view of this rule. So have a this rule. Then we deal with that issue. Second issue will be that I have replied to all this is my search sheet, this is my reply, this is their evidence, but their decision is perverse. Not beyond that, perverse means that though evidence is something, they have taken a decision which is contrary to the evidence. This is your third position. Then other aspect will come that mala fide exercise by Mr. Das's client. So therefore, we need a note of arguments. Mr.
Ma'am,
You also
we
prepare.
prepare one.
You also, when can you come next time?
But I can give it details on that today itself also.
You are not getting. Today you giving Mr. Bothakar. Let him understand. You can give that. That is not the way. We'll also have to apply this mind. Otherwise, these 3 volumes, whole days will go. We don't have that much of luxury. All are waiting. So we'll have to hear everybody. We'll have to give patient hearing. At the same time, we'll have to be precise.
But during the disciplinary process and even in this honorable court, they could not confirm not a single serial. They could not confirm.
That is your argument.
Yeah, and they did not mention anything specifically. They just give random statement and manipulate their own document and own statement during the disciplinary
So
process.
you have
And
to
now,
give us a note of your argument, short note. You cannot expect us to go, what is a vital? Suppose this is an rule. What is the important point of your rules? Give us that. Where do you stay?
what is that, Lordship?
Then you can come. Are you engaged somewhere after dismissal?
Lordship, this honorable court already considered my matter as urgency, Lordship, by order dated 8 January 2024.
Which order?
8 January 2024.
23 matters. 8 January.
2024.
We know why this order has been passed. You don't want an assistance of a lawyer also.
So I have took the assistance, the service for a period of 3 years, but I have faces lots of inconveniences. I have written down everything in my
But
application.
problem is that you might be the inconvenience for the court because you will have to understand how to argue in a writ court. This is the difficulty. Of course, we'll give you patient hearing, but it will not be possible today. Until and unless if you give brief arguments or brief note of arguments of yours.
Lordship, in the second half, I'll give the brief argument.
Not second half,
very
give a date,
proceed-
give a date. Next week, give a date.
Today, second.
Today, so many matters are fixed in the second half. Give a date next Tuesday, Thursday.
First week of September.
Lordship,
Give a date as per his convenience. Next week, you may give a date.
next Thursday, Lordship.
Next Thursday. Please assist us. Everybody we are asking. Don't take it to be an adverse, just point out what is his argument all, because ultimately we have to accept that he is not having that experience of arguing like a lawyer.
Assistance, madam.
No, he has refused it.
Yes.
I have took the service for a period of.
No, that is not our, no.
Even in this honorable court, for a period.
Then you will have to be, you will have to argue like a lawyer.
Lordship,
We will not tolerate the things beyond the scope of this court. Okay, so you have two options. Court offered you a free legal assistance. You have refused it. So we'll expect that you will be as good as a lawyer. You know the law. You know the principle when departmental proceeding, judicial review is to be done. What is the scope of judicial review in the case of departmental proceeding? Tell us.
in case of Lordship.
Judicial review in case of a departmental
In
proceeding.
case of Lordship.
Scope. To what
violation of-
extent can we go?
Violation of natural justice.
Ah.
Illegal rights.
Violation of natural justice. Then
Illegal rights, Lordship.
what illegal rights?
If the person do not have the authority to act as the.
That is we call and the authority who has passed is not having sanction and authority under law and jurisdiction. Second, third.
Third, violation of fundamental rights like Lordship, not giving equal opportunity, not giving.
No fundamental right violation question is there here.
Next week, I will have some difficulty. Can it be on either on third or fifth, my lord?
Third or fifth? Which one?
Third.
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 As agreed to with the learned council for the parties, list this matter on 3rd of September. Full stop. As the petitioner is personally present and he has prepared a writ petition consisting of how many volumes? 3 volumes. Huh?
3 volumes.
3 volumes. Therefore, this court will expect that the petitioner will also prepare a short written note of his arguments and point of issue by the next date fix. Full stop. List this matter accordingly on 3rd of September.
All right.
Item number 10 and 11. Look, can I pray for taking up the matter on 29th?
29th. 29th, yes. On the prayer of Mr. Dinat, learned senior government advocate, let this matter be listed on 29th. Somebody ask somebody that we have called for the case there is not it? You ask somebody to go through it. Yes. Yes, anybody who do not want to be after post lunch.
Thing is that, my lord, first instance earlier, he detained that one case is there, he released on bail. Subsequently, that this incident, once my lord go to the 164, already succeeded. Now, it is not yet suggestion, but evidence as per this, my lord, on 29.6, fixed on 26.7 for evidence. We don't know whether at least till her, only kindly go through the 164.
No, I have seen that. That's why, see, otherwise, if you go through the FIR and other materials, kind of a petty offense. But the way he has tortured his and he tortured this lady beyond imagination. We have seen that 164. That's why we have not granted bail at this stage. Now, charge sheet has been filed immediately. Now, that I recall. That's why. Otherwise, for this court, this is not a case to refuse a bail. But the conduct, I have still doubt whether coming out, whether he will again do the same thing because he's having some difficulties.
We will comply with all the terms and conditions that.
When the last date was?
As per this note, last date here is 29.6, fiction 26(7) for evidence.
Hmm.
So it is gone. Now
You do
whether-
one thing, we are taking this, lower courts are also on holidays.
No, lower court tomorrow. Tomorrow may be holiday. Tomorrow
Monday?
may not be.
Monday,
Tomorrow may be open, my lord.
Monday also holiday. Monday
huh?
is also holiday.
Open. Tomorrow is also open.
Yes, tomorrow is also a holiday.
You have a downloaded copy of the order. Come back to us on Wednesday.
Yes.
What happened on 26th? Okay, we'll not call for scan copy general. At least you do that,
Yes, yes.
that much for your bail.
Let us.
Huh? What happened after 20?
26(7). Just fix up 26(7) for
Okay, we are not recording anything. You bring that document because this matter will come before this bench only. Huh? What happened on 26/7? Any examination is made or not? Okay. List this matter on Wednesday next.
Oblige.
I recall that. Our statement 164, 161 thoroughly describe how we tortured this. Hey, there is a judgment here. Blue, very good. Blue, very good. 30% latest, लेकिन दसल. Let us see the order of the trial court. No, order of this court. Order of this court. Order of this court. Let us see. What is the findings of this court? What are the grounds for allowing this petition?
The ground. Actually find it order is 48. The order dated 27/4/2001. May I read your check? The operative, the court is, let's say, started from the page 52.
Just a minute.
Now.
That has not been considered for final determination. That was a passing comment.
No.
That may be incorrect, but reason is something different.
Paragraph 9 of the lordship judgment.
This court's determination is starts from paragraph 12.
The lordship, no.
These are the passing comment. That if this is not the ground for granting injunction.
No,
The ground of granting the injunction is from paragraph 12.
I'm submitting, lordship. When this court is taking into consideration of that order, the passed by this court. See, generally the principle of granting the interim.
No, let us not go to the merit.
I'm not going to merit.
Please show us what is the reason of this court granting injunction,
Yes.
which
Yes,
starts
lordship will
from
find.
paragraph 12.
No, lordship will for the
The
start.
basic fundamental reason taken is that the property should be preserved. This is
No,
the
no,
view.
that-
That
that-
view may be wrong
no,
in the given
No,
facts.
no,
That
that part is different. My submission is when the court is passing the order to have come to a conclusion, on the basis of the findings, Paragraph 9, lordship is permit.
No, I've read the paragraph 9. That's
And
why
then-
from 9 to 16 I have read in the meantime.
And my submission is that the material which is produced, the court said that the appellate court rules of the recent judgment that if the ground which is giving is a pristine in quality, which is taken into consideration would have logical effect in the reversing judgment. I have given a judgment in last occasion. Paragraph 21. So kindly have a look. I wonder.
See, kindly come to paragraph. We'll go to all that. See, what is the ground? From the pleadings of both the side, it is clear that defendants had not disputed about the oral agreement or receipt of the advance of rupees 10 lakhs. However, it is the case of the defendants that because the plaintiff is not coming forward with the written agreement and has not paid 50% amount required for obtaining sale permission, they had not executed the sale deed. Thus, the contract and role of the defendants are not in dispute, and at the same time, plaintiff has expressed that he is still ready and willing to pay the amount required and submits that he has given the written agreement with defendants are not signing. Such dispute whether plaintiff is ready and willing to execute the sale deed is a matter of trial. This is the first finding. Second, it is by now well settled prayer of grant of interlocutory injunction is at the stage when existence of legal right is asserted by the plaintiff. In the present case, his right to get agreement sale specifically performed and its alleged violation. In the present case, the plaintiff has not come forward to pay the cost of obtaining sale permission and the written agreement. Are both contested and uncertain, and same will remain uncertain till they are established in trial by evidence. Third, therefore, as held in World War II, the court at this stage, action certain well settled principle act on. This is written action, but it should be act on certain well settled principle of administration of this form of intellectual remedy, which is both temporary and discretionary. The object of interlocution is to protect the plaintiff against injury or violation of his right, for which he could not be adequately compensated in damages recoverable in action. If the uncertainty were resolved in the favor of the trial, such rights is to be balanced against the right of the defendant to enjoy his own property. As held in ENSOC, such remedies intended to preserve in status quo the right of the parties which may appear on prima facie, and such development is based on balance of condition. In the case, the learned below has rightly found prima facie case and balance of condition in favor of the plaintiff.
Yes.
Now your is that according to you, balance of convenience was not found in their favor. This is your case.
My case is that, what I'm saying, that
Prima facie case is there is no dispute.
prima facie case, I am no, the prima, there was a prima facie case and balance and convenience, and the irreparable loss and injury. The trial court, while holding the prima facie case and balance and convenience and irreparable loss not in favor of the appellant. The court.
So therefore, like now come to you will have to read paragraph this line, paragraph 12,
Yes,
paragraph 14,
9,
paragraph 15. Now read paragraph 15. taking the matter from death the interview on the basis of pleading. Why? On the basis of which? On the basis of pleading made by the parties and discussed herein above. This court is of the view that during pendency of the proceeding, the learned appellate court ought to have protected the nature of the property from being changed, which include alienation or transfer of the property, and which may lead to loss or damage being used by so and so. This is the reason of paragraph
Right,
15.
yes, I'm agree. What I am saying, when the lordship would.
What is the stage of the suit now?
What is,
Your lordship, evidence is going on.
Plaintiff's evidence going on.
and lordship will see, because of balance, because the case when filed without having any document, any time of the trial court is specially stated. And
Where
the
is
token
where is the paragraph in the trial court judgment?
yes, lordship find paragraph, the trial court judgment lordship find from
Trial court judgment?
trial court judgment is 50.
Two.
Lordship will 51. 51 last paragraph from the start. Now, what exercising law relating the grant of temporary injunction? Does it find it?
Yes, sir.
Yes. 52. While the law temporary injunction, the court has also stated whether the plaintiff has a strong prima facie case, whether balance and convenience in favor of the plaintiff, whether the plaintiff would suffer irreparable loss of injury if the payout of temporary injunction is allowed. If the relief by way of temporary injunction is granted to mitigate the risks and injustice to the plaintiff during the pendency of the suit, such injustice that may be caused to the plaintiff is to weighed against the corresponding need of the defendant to be prevented against the injury resulting from preventing him from exercising his legal right. Court is therefore weigh the plaintiff need against the defendant determine whether the balance is conveniences lies. Court is also have to see whether the refusal of injunction would cause irreparable loss to the plaintiff. Hardly both sides peruse the cases record. The document annexed with the plaintiff. Upon perusal of the case, it is seen that the photocopy of the money receipt that at 4/8/2020 executed by the opposite party 1, the bonding check in favor of the plaintiff, petitioner Pavitra Boro has been furnished. Upon the perusal of the said money receipt, it is seen that the opposite party number has acknowledged the receiving of the amount of 10 lakh from the petitioner as a token money, advance money for the purpose of transfer of sale, a plot of land measuring 11 bigger 1 kota, so and so, covered by so and situated. It is also seen that total consideration sale should value is fixed at 62 crore 20 lakhs, 62 per bigha, sorry. Bigha deed agreement of sale that shall be made between the seller and the purchaser within 1 month from the date. However, the terms of oral agreement for it between the parties has not been furnished by the petitioner, except the money receipt. Nothing placed before the petitioner for this court perusal. Nevertheless, from the money receipt, the submission, it is seen that plaintiff has a prima facie case as he advanced an amount of 10 lakh to the opposite party in order to buy Schedule B land. But as alleged by the petitioner that separate from a return agreement was prepared and placed before the opposite party on 4/9 for signature, along with a check of 40 lakhs towards the part payment of the sale consideration for Schedule not has not been placed before this court for establishing the petitioner case.
At that point of time, written statement was not there.
And even
Written statement was there.
only
But then written statement, you have admitted all these
No,
things. What is the
there is
necessity?
true.
That is the findings of this court.
They filed that objection has been filed. And see, then nothing is filed. And even then, after the case suit is instituted, they file an application for taking it to the check to the suit, the plaintiff. That is hearing that is also rejected by this trial court. That without having pleading in the plaintiff, you cannot subsequently you can make this Then that is now position. Now Lordship will find the sale did non-acceptance payment of 40 lakhs opposite party. The same can be ascertained at the trial. I mean, from the entire discussion, it is also seen balance and compensation lie in favor of the petitioner, as they are unlikely to suffer hardship injury if the agreement of sale is alleged is finalized between the parties. The petitioner is anyway not in possession. It will be plotland. So he does not imminent threat of dispossession or ejection. The petitioner is also unlikely to suffer the irreparable that cannot be compensated in terms of the, because their petition, they have a specific alternative payer that for return of money of 10 lakhs with 18% interest. And merit, if lordship go to the merit, even if you lordship allow me to go to merit of the case, I can show you this case itself is not maintainable. The case itself in view of the section 15 and 51 of the Contract Act, 17 of the specific, the should even go to the merit of the case, that is not even maintainable as maintainable, non-maintainable, because of the fact that their admission, their suit property, which they say that there is an order agreement, there is no oral agreement, there is a negotiation, there is no concluded agreement. They say there is no concluded agreement. There is property is not belong to this person who received the money and who said that he on behalf of that, there is no whisper in the money received, that they have received the money on behalf of them. Only to be said, seek property, if their amount is required to be considered, is it true? The property value is come around 6 crore 99 lakhs. And the amount they offer, that is we share what is by now, which is there, is 10 lakh. And therefore, court says that it is not a case for giving.
Where is the plaint?
Then proceed to find.
Page 14.
Page
14.
26.
Annexure 1, the review.
Page 14. 1-4. Prayer portion.
Prayer lordship will find is page 22.
That's at page 21.
See, in alternative, the agreement said
No, this is a mandate of specific persons act, is not it?
18% interest.
This is to be given under specific new act, isn't it?
Yes.
Alternative prayer is must be there.
There must page 22.
No, I have seen that. That prayer, what is the provision of specifically prayer?
Section
Amended,
amended, Your Honor.
new act.
Section 16. Your Honor.
What it says? There are some judgments also.
Yes. Your Honor. Specific performance of contract cannot be enforced in favor of a person.
In specific act, in fact,
See,
there must be a declaration and
No, no, just see.
who fails to prove that he has performed and has always been ready and willing to perform the essential terms of the contract which are to be performed by him other than terms of performance which has been prevented or waived by the defendant. Explanation: where a contract involves the payment of money, it is not essential for the plaintiff to actually tender to the defendants or to deposit in court in any money except when when so directed by the court, Your Honor. In the event of failure, Your Honor, suppose we are not going
There's
to.
some judgment, Supreme Court judgment, where it says.
Actually, what happened, you all also?
No, here.
After amendment, it make the special performance of contract is become mandatory as per section 10. Because earlier it was, the word was used maybe, but now it is substituted by the word shall be.
Read it.
Section 10, special performance in respect of contracts. The special performance of a contract shall be enforced by the court subject to the provision contained in subsection 2 of section 11
section 14 and section 16, your lordship.
That is well defined. We read it.
Yes, your lordship. So you,
Mr. Borua, still we are in your favor. Slightly. I was in your favor absolutely on last occasion. But slightly now, I have deviated from that view. Let me be frank. So you'll hear him properly, hear you too, you also. You have waited so many days, wait for this weekend.
Use that time.
Tuesday, Thursday. We have not been able to apply mine. Ultimately,
Fairly subject, I want to, so the lordship will see.
no, there was a mistake. There is a mistake, error apparent, that we have recorded something which is not on record. That is one. Now, whether that part is relatable to the ultimate decision, this is the
Yes.
second.
Yes.
If that is relatable to the ultimate decision, then foundation of the decision is
Yes.
error apparent on the face of
Yes.
the record, then we'll have no option but
Yes.
to recall.
Lordship rightly says that is what is apex court says.
Let us not go to that, Lord, let us not go to the apex court judgment. Whether it is a passing comment or ultimate decision is
Effect.
rested upon these wrong findings of fact. If it is wrong findings of fact, then we'll have to recall this order.
Yes. So I'm agree with lordship because in injunction, three principles.
Because in the last, because we'll have to apply our mind. In last paragraph, penultimate paragraph, what this court has said is taking view of all those facts and aforesaid. What is the aforesaid? So we need some application of mind.
That is what this court says. Apex court. Lordship will find that.
No, apex
I
court
am
judgment,
just-
I have gone through, I have taken
No,
it
no.
to home.
I am that
This is-
the
this is
material
the-
body discharge should be such a distant quality if taken into consideration would have a logical effect of
That's what-
reversing the
that's what-
judgment. Logical reversing.
So therefore, let us take it some other day. Muslim, give a date.
Kindly fix a date.
No, we'll fix a date. Otherwise, this will come to dispensation.
No,
But therefore, we'll fix a date.
And why I'm pressing so hard? Because lordship, see, lordship.
See, this court is having no problem accepting that we have committed a mistake. No problem on that.
Lordship will consider.
But we'll have to properly adjudicate that whether this is having a reasonable nexus with the finding.
Yes.
If it is a passing comment, maybe a wrong fact we have recorded. Whether if it is having a,
Yes.
we'll have to argue on that point. Okay? Don't go to all other things. If it is having a reasonable nexus, then we'll recall it and send it to the appropriate bench
And
where it is to be taken afresh. That's all.
this thing came to my mind only because of fact that the logic judgment, which is stated in the basic of the judgment, the word Entok judgment. The Entok judgment, the paragraph 9, I read twice in paragraph 9. In paragraph 9 said regarding specifically regarding balance and convenience. That judgment is also trial court rejected.
No, Entok judgment is a beauty of the judgment is you can use the judgment for granting, for refusing both. There are two paragraphs.
Yes.
Just quote this paragraph and that paragraph fit into the case.
That-
Entok judgment's beauty is there.
Yes,
You
like
can
two ways.
apply in both two ways.
Yes, both can. Both can.
Okay.
lordship, may I?
No, not today. Just be prepared. And also prepare, that's just for our clarification. We may not go to that level. That otherwise that alternative prayer. You just, since he has raised it, just be ready with him. As agreed to by the learned counsel for the party. Sorry for we kept you.
And I am here. Except 13 September to 20.
Okay. As agreed to by the learned counsel for the parties, list this matter. 9th of September.
9th. He has a audition in the radio.
Okay. When then?
Any day, he will not be available from
After 13th?
to 20th.
After 20th?
After 20th.
Give a date after 20th of September. 25th. You also ready. Be ready.
Because of the fact that
Keep this judgment inside.
this case, we are already preparing a plaint for rejection of their plaint, but I could not file because of the pennies of this case. Because it is their admission, section 15, Lordship, I am there, space for specific performance and 51 of the Contract Act. I have to, Lordship, the person who have the
No, we'll not go to.
title can also only get.
We'll think on it, just satisfy, yes.
For further hearing, Lordship.
Ah.
For further hearing.
Otherwise, you
Oh,
can
yeah,
come
they
even
can come
later.
here.
Till I am here. You are Mr.
Pankaj Mehta.
Mehta. Okay, start. We may not be able to conclude it today.
Milord,
We'll have to come once.
Milord,
Okay, just summarize the things.
sure, Milord.
Which are the clauses? There is
Milord,
a-
I'll show Milord. Milord, to have a better clarity,
Hmm.
Milord, there are two aspects in the impugned order. One is forfeiture of my
EMD,
bankruptcy
etc., etc.
and EMD, and
You
second
are
is
not,
debarment.
you are not against termination.
Milord, I am against the termination also. Of course, these are the consequences of the termination, Milord. Milord, what has happened is they issued a tender document. After the issuance of tender document, they verified all the credentials and issued a letter of award, which is after 6 months of after issuance of tender document. That is the time taken for them to evaluate before they conclude that this is the L1 contractor whom they want to give the contract. They issued a letter of award to me. They issued a letter of award, and after the letter of award is issued, they said that please submit the performance bank guarantee. I submitted a EMD while submitting my bid. So there is a clause in the tender document, instruction to tender document, ITT document, that in case if any document is found to be false, fabricated or forged, then we will forfeit you and we will blacklist you. My lords, this has happened. They did not inform me. After I submitted my performance bank guarantee, I mobilized my resources. I spent, apart from this 3 crore rupees, 3 crore 8 lakh rupees, I incurred approximately 1 crore for the resources.
That we understand, but that is again question of dispute, whether you have spent 1 crore or 100 crore.
Milord, I'm not.
That is of no business.
Milord. Now, the show cause notice which has been issued.
Now let us show the provision under which the action is taken.
Milord.
First,
First,
because we are not concluding, we just will have an understanding today.
Milord.
Yes.
First, it is show cause notice, Milord.
No, before the show cause, which is the clause?
Milord, it is mentioned in the.
No, I want the clause, it's to read the clause itself.
Yes, Milord. Kindly have page 41
Page,
of my page 41. Annexure E,
page 41.
page 41.
Just a minute.
That's the show cause notice only, where they mention the clauses.
Page 41. Just a minute. Page 40.
Page 40. Page 40.
Ah.
Page 41 is a para 3. This is a show cause notice, where they mention the clauses also.
What are the clauses?
In view of the above para 3, Milord. Has it in the show cause notice? In view of the above circumstances stated herein above, you have violated the tender condition available in tender document wide appendix 3, instruction to the tenderers, para 5, para A, subclause para 5. That if any one or more of the detailed information furnished in the tenderer's document is proved to be false at any stage, the contractor firm will be debarred then and there and from all the commitment connected.
Now, what is the wrong information?
Milord, one of the document which I submitted.
What is that document?
Milord, that is the credential for my experience certificate. Undersigned, I have re-verified the document para 2. It is clarified that the executive wide is letter dated so and so. As per record, no record of message Satya Builder exists wide agreement number so and so.
Now, yes, tell us what is your explanation to this?
Milord, I'm coming.
Just show us. We'll give you a person here.
Milord.
Show us your reply.
Milord, para 5 and para 7. And then similarly as provided, para 7, if in case any wrong information submitted by tender,
No, that will come later on. Please tell us your reply.
Next second, they say, as provided in GCC clause number 62, para 14 BF, submission of copy of fake document certificate in support of a credential by the tender railway shall be entitled to be resigned the contract.
We have read it.
No,
Very fast in reading.
no,
Please,
Milord,
please
let's
come to the vital point. Let us not waste time.
Milord,
Will your reply to the so-called?
Milord, come to Milord, now they filed a reply
After this, they terminated me. Para 50, page 53.
What is page 46?
Reply. Wherein I said that I will submit, this is page 46, my lord. With reference to a letter mentioned above in subhead, we would like to clarify that the use of wrong credentials by one of our staff and due to time and pressure to submit the bid work mentioned in subject has created this situation. However, now,
So you admit that this was a mistake.
my lord, I admit it.
You admit it.
I admit it.
But your whole case is, why are you sleeping over?
No, my lord, this is not the only case, my lord. Apart from why you're sleeping off for 1 year, as per the contract, I had the remedy, I had the right to amendable. If this is amendable, I can correct it.
No, you cannot correct this.
My lord, it is mentioned, my lord. It is in
You
this.
cannot correct this. If you say that I have an experience of working with so-and-so organization, and on the basis of that you have been awarded the tender, and later on you said that yes, it was my mistake.
I submitted another experience certificate that this was a wrong certificate given. I admitted it was a clerical mistake. This was not, this was some mistake.
You are a prudent businessman.
Milord, let me submit, milord. Give me some time, milord.
Better you do not submit today. I have understood your case.
Milord, clause 6.
Okay, accept that part. If there is no notice for your thing and all, what is their decision, that part. Otherwise, we are not going to touch this decision of termination, forfeiture of AMD, nothing. You go to arbitration.
Milord, kindly see it for a minute. Kindly see clause 62.
Do you still want to go
No,
for a
milord, I will
minute?
take,
You take an adjournment.
milord,
When?
as per the
You are
convenience of
safe
milord.
because of the second half, too many meters and ensuing 4 days vacation. Mr. Dasgupta.
Grateful, milord.
When?
Fix a date.
We'll fix
September,
it, huh?
September.
So give a date, September. Why this matter is listed in hearing? We'll fix it in the orders. It will be better for you. It will come in the order column in the first, or you make a mention for this matter.
Let it become for order,
Milord.
because there is some interim order is there.
It is fixed.
What interim order?
There is a stay has been granted on this.
What is that interim order? Tell us.
Blacklisting.
Blacklisting.
Let him walk. Otherwise, you will not give him a walk. Have you given him walk? 19 he was blacklisted.
He's my specific submission is the instruction is he is continuing to apply for tender work.
Submitting work tender.
Tenders, and that is where I'm creating problem.
Milord, if I'm blacklisted, it is like there have been catena judgment that it is several days. I will not be able to perform it.
Already 3 years elect.
No, that's why I'm saying. So he was blacklisted in a 19. Is that it?
No,
21.
20. Huh?
21.
21. 22, 23, 24. Only 1 year is left. 2 years is left. So, okay, give a date. We'll decide.
Milord, can it be on
See, you remind yourself and we also remind ourselves our limited scope of inquiry. Except for the blacklisting. We are repeatedly saying. Blacklisted parts, of course, it's a 21 violation, 19 1G, many things are there. But so far relating to the termination of the contract, we do not find any perversity or violation of any right under Article 14. Therefore, prima facie view, subject to what you say, this is not a case for interference. Interference more particularly when this is not a statutory contract. There is still that MP judgment.
Milord.
Till the MP judgment, in fact, Supreme Court time and again says, regarding contractual dispute, termination, forfeiture, please do not enter into this until and unless it is statutory contract.
Milord.
Subsequently, in Madhya Pradesh, my Lord Justice K.M. Joseph
Milord.
has summarized all those judgments and given a limited scope for interfering in a judicial review so far relating to non-statutory contract like yours.
No.
But there also parameter is very limited. Article 14, but primarily Article 14, and it should be on the face of it. So we'll not waste time reading all these judgment. Bring that judgment. And paragraph, I forgot it, that has been all judgments discussed and summarized the principles.
Milord, I have given the written submission where I have summarized all.
Your written submissions and I have seen, I will not go to all this. This is not called a written judgment. This is called a research paper. We do not want that. Okay?
I'll come on that.
That is only. You will have to satisfy, see, this is a non-statutory contract. And MP judgment, my Lord Justice K.M. Joseph, what is the judgment? I forgot. Huh? That is the judgment. For him also, for you also. That principle is laid down. We'll see in that parameter whether that is violation is there. If not, then we will not interfere. You relegate you to your appropriate forum without commenting anything on merit. And so far relating to the blacklisting, we will consider in the principle, settled principle of that principles of natural justice and determination. That's all. This method should not take more than half an hour. Will not go to what happened, what not happened, nothing.
Milord, that is what I am submitting.
Issue is simple. There was a show cause notice. There was a clause. We'll refer to the clause. Show cause notice, allegation. What is your reply? We'll have to be satisfied that your reply, on the basis of your reply, they could not have or terminated the contract. That's all.
Rather, they have only replied that we have not terminated your contract as per the instruction to tender the clauses which two clauses I read. They said we have signed the contract under 62.41B, which says that in case even if the fake document has been submitted, they will issue a notice for me to amend and submit the fresh. This is what.
So you want to say, even if you commit fraud, they will allow you.
This is what the general condition.
Okay. You address on that. That their clause permits a fraudster to modify, rectify his document. That's all. If you can satisfy, we will ask them. We will give you all the relief. That's all.
I'm so grateful for patient hearing, Lord. And Milord, the date may be given, time may be fixed, Milord, or it.
Will you make a mention if it comes before this court? We'll upgrade it since you are an outstation lawyer.
Yes, sir, that will be better. You
That
have
would
to
be
fix
better.
a date.
You will give you.
Milord, can it be on September
What is the judgment? Huh? 19th of September.
19th? Milord, I have a matter in Delhi High Court. 20th is also.
Give a date as per your.
20, can it be 23rd of September or 23rd of September? 23rd. Or after 24th September is any date available? Milord? I am 24 September. Yes.
Give a date.
26th September. Grateful, Milord. I'm so grateful for the patient hearing, Milord, and giving opportunity, Milord.
Yes, we'll give you patient hearing next date also.
I'm so grateful, Milord.
That judgment is. Just take note of that judgment. MP Power Management Company Limited versus Sky Power Southeast Solar India Private Limited. I do not know the citation. MP Power Management Company Limited versus Sky Power Southeast Solar India Private Limited.
How?
Southeast Solar India.
How?
East Solar India Private Limited. By my Lord Justice K.M. Joseph and Rishikesh Roy.
Milord.
All the earlier judgments of judicial review so far relating to contractual dispute. This is a contractual dispute, not tender dispute. This is a contractual dispute.
I have cited one in my written submission. I have also given one judgment on the contract issue, section 73 of the Indian Contract Act.
No. This is judicial review.
Yes, ma'am. the judicial review.
Which judgment?
Milord,
Tell us.
It is Honorable High Court of Calcutta, Sushil Kumar III versus National.
No, you go through his judgment. All previous judgment of judicial review on the contractual dispute, almost all earlier judgment, it says that High Court should not interfere in non-statutory contract. Your one is a non-statutory contract. But in this case, said no, this is not an absolute rule. There is an exception. And what are the exceptions? That principle is laid down.
K.M. Joseph. You know,
K.M. Joseph and my Lord Justice Rishikesh Roy.
Oh, yes. 2022 live law.
No, SCC.
No,
You give that SCC.
Okay, I'll.
This is the judgment for both of you. We'll see the facts in the parameter of this judgment. That's all. We need not go to many judgments, many things. So therefore, I'm saying we'll not go to your written argument until and unless you give written note within 2 pages.
I'll give a written note within 2 pages.
2 pages.
Milord, I think my written submission only of 2-3 pages, only judgments, there are judgments there. It is only, I will submit. Milord.
Yes.
Milord, it
That's
is little bit bigger. The facts
20,
are
20,
already running.
20,
26.
26 is a,
I'm just.
26 is it? That's just-
Milord, I got the citation also, the judgment your lordship had mentioned. This was civil appeal number